Why Sui Juris Trustees should rethink 42 U.S.C. 1983 actions. Subtitle: How to assert standing, status, and jurisdiction without trapping yourself in the 14th Amendment person box by DFW Dad. 3333. Advanced education purposes only. All rights reserved. 2025. They fear the scroll more than the sword. Be the scroll. The core problem: citizen and person in the wrong jurisdiction. Many living men and women acting in propria persona and standing in equity unknowingly contract themselves back into the corporate jurisdiction they are challenging by filing a 42 U.S.C. per 1983 civil rights complaint in federal court. Why? Because the statute itself is framed for U.S. citizens and persons under the 14th Amendment, which are legal terms of art, not the same as the living man or woman in their private capacity. When you accept and use their definitions without challenge, you risk conceding personal jurisdiction by self-identifying as a statutory person, conceding subject matter jurisdiction by invoking a remedy written for 14th Amendment entities, moving your entire matter out of private law and into their public corporate venue. This is why the man you quoted is saying 42 to 1983 isn't plausible if you've changed your status and are no longer in that statutory category. Cashier. The alternative framework. If you are operating as trustee or beneficiary of an irrevocable private express trust, the proper way forward often begins privately, exhausting remedies outside their statutory courts before ever stepping into a public venue. This means 1. Private administrative action. All communications done privately, on your letterhead, invoking equity, trust, and contract principles. 2. Conditional acceptance. Agreeing to their offer upon proof of claim that they have jurisdiction, authority, and a valid contract binding you. 3. Fault. Opportunity to cure. Give them a fair and reasonable chance to correct their errors per maxims of equity. 4. Certificate of non-response, non-performance. Create the paper trail showing they failed to rebut your claims. 5. Final default and dishonor. Close the matter administratively, sealing your standing. 6. Record a UCC-1 lien. Perfect your claim against their commercial activity involving your trust or estate. 7. Private litigation. Now with your perfected record, you can step into an Article III court as claimant in equity. Why this matters for Sui Juris Trustees. A private express trust exists outside their corporate franchise system. Once you stand in that capacity, you must be extremely careful. Public venue, danger. Private venue, protection. 42 U.S.C. per 1983, citizen-person remedy. Trust indenture enforcement in equity, implied statutory consent, explicit trust law standing, public civil rights claims, private property rights enforcement. Court rules control your status. Trust instrument controls the case. If you start in their world using their definitions, they already have the upper hand. If you start in your private trust world and bring your perfected claim forward, you hold the pen. Questions you should be asking before filing anything. Have I identified myself anywhere as a person or citizen without rebutting their definition? Have I created a complete administrative record that proves my standing and exhaustion of remedies? Can I prove my capacity in trust law before any court without depending on statutory civil rights codes? Am I bringing a claim as a living man or woman or as a statutory entity? If the court is not Article III, how do I compel them to prove jurisdiction first? Key takeaways. If the man you quoted is correct, and in equity he likely is, then 42 Packard 1983 is a trap for the unwary when used by someone who has already claimed sui juris status outside the corporate system. The safer path is private first, public last, exhausting all contractual and equitable remedies before entering any court. That way, when you step forward, you're not petitioning as a citizen begging for rights, but as a trustee or beneficiary enforcing rights already vested in trust. Final word: move like Thoth with precision, Ma'at with balance, Gandhi with peace, Confucius with order, and James the Just with truth. The pen here isn't just mightier than the sword, it's the only lawful sword you need. Want DFW Dad's TikTok post transcripts as a printable PDF? Private community access. Donate $8 to join. DFW Dad's exclusive private Telegram group plus resources, transcripts, guides, group chat plus edu. What's inside? Education docs, book downloads, live group chat, AI education coaching, DFW Dad's video transcripts. How to join. Donate $8 via Cash App dfw.cash.app to DFW3. Venmo at DFWDad33 DM after and let DFW Dad know you made your $8 donation. One-on-one AI coaching and private exclusive education offers, guides and books. 29 personal step-by-step mindset guide, $144. Occult child support secrets book, strategies and tactics, $889. Child support templates, educational use, coming soon. Phone coaching, AI education, $49 20-minute session, $89 40-minute session. Premium services, $249. Occult contract law, tarot reading, 4-hour sessions, Weight Rider deck, $899. Cancel child support event, live in DFW, Father's Day 2026, 12+ speakers, $1,499. Weekend with DFW Dad, $3,499. Full week with DFW Dad. Next steps, DM to schedule after donating. Buy DFW Dad 33, Advanced Education Purposes Only, all rights reserved 2025. They fear the scroll more than the sword. Be the scroll.